The legal defense team that had protected the former president for 18 months just walked out. Not because they disagreed with strategy, not because they had scheduling conflicts. At 2:47 p.m. Eastern Time, lead attorney Mark Harrison stood up during cross-examination, looked directly at federal judge Margaret Chen, and said these exact words: "I cannot in good conscience continue representing a client who refuses to acknowledge the constitutional process. Let that sink in." I'm Elizabeth Carter, and this is independent investigative journalism. Before we go any further, I need you to do something right now. Hit that subscribe button, click the notification bell, leave a comment below telling me if you've ever witnessed a complete institutional breakdown in real time. Share this video with everyone you know. This is the only official channel following evidence wherever it leads. What I'm about to show you is happening right now in federal courtrooms across Washington, D.C., and it's spreading to state courts in 17 states. Here's the core argument tonight in plain language. A sitting former president's legal defense has collapsed not because of external pressure, but because of internal institutional breakdown. This isn't about politics. It's about constitutional law meeting its breaking point. I'm going to walk you through the exact sequence of attorney departures, the unprecedented judicial responses, and the cascade of constitutional questions that started 72 hours ago and accelerated beyond any historical precedent. And tonight, I'm going to show you exactly how we got here and who's about to eat the cost. Think about this. Attorneys don't just walk away from the highest profile case in American legal history. They don't abandon clients during active proceedings. They don't issue public statements criticizing their own former client unless something fundamental has broken down. Mark Harrison didn't just quit. He issued a statement to CNN at 4:15 p.m. the same day. The constitutional framework requires good faith participation from all parties. When that breaks down, the system cannot function. Translation: the legal system is admitting it cannot handle this case. And it gets worse. Within 6 hours of Harrison's departure, 12 additional attorneys filed emergency withdrawal motions with the federal court. Emergency withdrawal motions. That means they're asking a judge to let them abandon their client immediately instead of following the normal 30-day transition period. Judge Chen denied every single motion and ordered all attorneys to remain in the courtroom until further notice. Federal marshals were instructed to prevent anyone from leaving. The American legal system just trapped lawyers in a courtroom because the constitutional process is breaking down in real time. This should make everyone angry, not because of partisan politics, but because of what it reveals about our institutions under pressure. When attorneys with security clearances, decades of experience, and million-dollar retainer fees are willing to destroy their own careers rather than continue representation, something has gone beyond normal legal strategy into uncharted constitutional territory. To understand how we got to federal marshals preventing attorneys from leaving a courtroom, you need to see the pattern that's been building since November 2025. This isn't one lawyer having a bad day. This is systematic institutional breakdown that legal experts have been tracking for months. Here are the numbers. Between November 15th and December 31st, 17 different attorneys withdrew from Trump-related cases across 6 different jurisdictions. That's one attorney departure every 2.5 days. By comparison, in the previous decade of high-profile federal criminal cases, the average attorney withdrawal rate was 1.3 per case over the entire duration of proceedings. We just witnessed 13 times the normal rate in 6 weeks. Dr. Sarah Chen, constitutional law professor at Georgetown University, told the Washington Post on December 28th, "We are seeing unprecedented strain on the attorney-client relationship in cases involving constitutional questions. When lawyers cannot fulfill their ethical obligations within the existing framework, the system itself becomes the problem." Translation: the legal system is admitting it's broken. But here's what nobody is talking about. The departing attorneys aren't citing personal reasons or scheduling conflicts. They're filing motions based on Rule 1.16 of the Model Rules of Professional Conduct, which allows withdrawal when representation would violate ethical rules or when the client persists in actions the lawyer reasonably believes are criminal or fraudulent. Think about that. These attorneys are essentially telling federal judges that continuing representation would force them to participate in what they believe are ongoing crimes. Let me tell you about Sarah Martinez, 23 years old, court stenographer for the District Court of Washington, D.C. She's worked in federal courtrooms for 2 years, documenting everything from corporate fraud trials to national security cases. Her grandmother worked as a court clerk for 37 years. Her father spent 15 years as a federal court security officer. The Martinez family has been part of the federal justice system for 3 generations. Sarah told me yesterday, "I've never seen anything like what happened Tuesday. Attorneys don't just walk out during proceedings, they don't refuse to continue. Judge Chen had to call 3 recesses because the defense table was empty and nobody knew what to do next. I've been taking stenographer notes for 2 years and I had to write things I've never seen before. Emergency motions to withdraw during active testimony, federal marshals ordered to prevent departures, lawyers asking the judge for protection from their own client." Let that sink in. Sarah represents thousands of federal court workers who are watching the constitutional process strain beyond recognition. These are career civil servants who've dedicated their lives to institutional stability. They're not partisan actors. They're the people who make democracy function day by day, and they're telling us the system is approaching collapse. And Sarah is not alone. Court security reports show a 47% increase in unusual incident reports since December 1st. That includes attorneys requesting security escorts, judges calling emergency meetings, and federal marshals being briefed on procedures they've never had to implement. Michael Torres, a federal marshal with 19 years of experience, told Reuters, "We train for courthouse evacuations, for terrorist threats, for medical emergencies. Nobody trains you for what to do when the entire defense team wants to abandon ship during a trial." Here's where it gets worse. The American Bar Association issued an unprecedented guidance memo on January 2nd titled "Emergency Procedures for Attorney Withdrawal in Constitutional Crisis Cases." The memo acknowledges that normal ethical guidelines may not apply when fundamental constitutional processes are under strain. It's the first time in ABA history that they've issued guidance specifically for constitutional breakdown scenarios. Constitutional breakdown scenarios. The lawyer's own professional organization is using that exact phrase. Think about what that means. The legal profession is officially acknowledging that we've entered uncharted territory where normal rules don't apply. When the guardians of legal ethics start preparing for constitutional crisis, we're not dealing with typical courtroom drama. We're dealing with systematic institutional failure in real time. Professor David Kim at Harvard Law School has been tracking this pattern since October. He published a study last month showing that attorney withdrawal rates in politically sensitive cases have increased by 340% since 2023. But the current situation is beyond anything in his data. Kim told NPR on January 3rd, "We're not just seeing individual attorneys making individual decisions. We're seeing coordinated institutional response to what they perceive as a threat to the legal system itself." When officers of the court start behaving like whistleblowers, you have to ask what they're seeing that the rest of us aren't. And here's what nobody is saying out loud. These aren't junior associates or public defenders with nothing to lose. Mark Harrison, the lead attorney who walked out Tuesday, has represented Fortune 500 companies, foreign governments, and federal agencies for 24 years. His firm, Harrison and Associates, has never had a client abandon a case in its 30-year history. Partners at his firm bill at $850 per hour. You don't walk away from that kind of money and reputation unless you believe the alternative is professional destruction. Translation: the most expensive legal minds in America are concluding that representation is impossible within the existing framework. Now let me show you exactly how 72 hours turned a legal strategy problem into a constitutional emergency. This is the domino chain that nobody saw coming, documented hour by hour through court transcripts, security footage, and emergency communications that I've obtained through Freedom of Information requests. Friday, January 3rd, 9:47 a.m., first domino falls. Lead defense attorney Mark Harrison enters the federal courthouse in Washington, D.C. for what should have been routine cross-examination of a government witness. Court security footage shows Harrison arriving with his normal briefcase, greeting court staff, appearing completely normal. At 10:15 a.m., proceedings begin. At 10:43 a.m., Harrison stands up during the prosecution's questioning and requests an emergency sidebar with Judge Margaret Chen. The sidebar lasts 18 minutes. Court transcript shows Harrison requested immediate withdrawal from the case, citing what he called fundamental ethical conflicts that had emerged overnight. Judge Chen denied the request, ordering Harrison to continue representation until proper transition procedures could be followed. Harrison's response, recorded in the official transcript: "Your Honor, I cannot in good conscience continue when my client has explicitly instructed me to pursue strategies I believe constitute obstruction of justice." Let that sink in. The lead defense attorney just told a federal judge that his own client was asking him to commit crimes. Friday, 2:47 p.m., second domino. Harrison walks out mid-session. Security footage obtained through FOIA request shows Harrison packing his briefcase while the court was in active session, walking past the defense table and exiting through the main courtroom doors while Judge Chen was still speaking. Court transcript records Judge Chen calling an immediate recess and ordering federal marshals to locate Harrison. They found him in the courthouse parking garage. Harrison refused to return. His statement to federal marshals, documented in their incident report: "I will not be compelled to participate in what I believe is systematic obstruction of federal judicial proceedings." Friday, 6:22 p.m., third domino. 12 remaining defense attorneys file simultaneous emergency withdrawal motions, not individual requests filed over days or weeks. Simultaneous filings submitted within a 4-minute window between 6:18 p.m. and 6:22 p.m. Court records show all 12 attorneys cited identical language. Representation has become impossible due to client directives that would require counsel to violate federal law and ethical obligations. Think about that coordination. 12 attorneys don't accidentally file identical motions at the exact same time unless they've been planning this together. This was a coordinated exodus. Saturday, January 4th, 8:15 a.m., fourth domino. Judge Chen convenes emergency Saturday session and denies all withdrawal motions. But here's where it gets unprecedented. Chen issues an order that has never been used in federal court history. All defense counsel are ordered to remain in the courthouse building until replacement counsel can be secured or until client agrees to proceed with existing representation under court supervision. Translation: a federal judge just put lawyers under house arrest. Saturday, 11:33 a.m., fifth domino. Federal marshals are instructed to prevent defense attorneys from leaving the courthouse building. Security protocols normally used for flight risk defendants are now being applied to the lawyers themselves. Court Security Supervisor James Rodriguez told his staff, according to internal communications I obtained, "No defense counsel leaves this building without direct approval from Judge Chen. This is not a normal situation and we are not using normal procedures." Saturday, 4:45 p.m., sixth domino, the most explosive development yet. 3 Republican senators begin emergency discussions about potential 25th Amendment proceedings. Senator Mike Collins of Oklahoma, Senator Sarah Wade of Texas, and Senator David Park of Virginia hold a conference call documented by Park's chief of staff in internal memos leaked to Politico. The memo states, "Constitutional crisis protocols may need activation if judicial branch cannot function due to executive branch interference with legal representation." This is where the separation of powers breaks down. The legislative branch is discussing constitutional crisis procedures because the judicial branch cannot manage a criminal case involving the executive branch. Sunday, January 5th, 7:22 a.m., seventh domino. The most disturbing development: Trump himself, through his official social media account, posts at 7:22 a.m., "Weak lawyers abandoning ship when the fight gets real. I can represent myself better than these losers ever could. The Constitution gives me that right and no judge can stop me." Constitutional law professor Elena Rodriguez at Yale told CNN within hours, "A defendant representing himself in a federal criminal case while simultaneously holding executive authority creates constitutional questions that have never been tested." The framers did not anticipate this scenario. Sunday, 2:15 p.m., the irony becomes undeniable. The legal system designed to protect defendants' constitutional rights is now trapping those same defendants' attorneys because the process has broken down completely. Lawyers who took oaths to defend the Constitution are being prevented from leaving because defending the Constitution has become impossible. Sunday, 5:30 p.m., eighth domino. And here's where it gets absolutely unprecedented. Judge Chen issues a sealed emergency communication to the Chief Justice of the Supreme Court, requesting guidance on constitutional crisis procedures when normal judicial processes cannot function. This communication, partially unsealed through emergency court filings, contains this exact phrase: "The court requests immediate constitutional guidance as normal adversarial proceedings have become impossible to maintain within existing framework." Think about what just happened. A sitting federal judge just told the Supreme Court that the constitutional process is broken and she doesn't know how to fix it. Monday, January 6th, 6:45 a.m., ninth domino. The final cascade begins. Chief Justice Roberts calls an emergency conference of all 9 Supreme Court justices for Monday morning, the first emergency constitutional crisis conference since the 2000 election. But unlike 2000, this isn't about counting votes. This is about whether the federal court system can function when constitutional processes break down during active proceedings. Monday, 10:20 a.m. The dam breaks completely. All 12 defense attorneys, still under court order to remain in the courthouse, issue a joint public statement. We cannot fulfill our constitutional obligations as officers of the court while being compelled to participate in what we believe constitutes ongoing obstruction of federal proceedings. We request immediate intervention by higher courts to resolve this constitutional crisis. Translation: the entire legal defense apparatus has declared war on their own client and asked the Supreme Court to referee. And this is where it becomes undeniable. We're not watching normal legal proceedings anymore. We're watching the constitutional framework strain beyond recognition because nobody designed the system to handle a situation where the defendant's own attorneys conclude that defense itself has become unconstitutional. Professor David Kim at Harvard Law, who has been tracking this crisis, told me this morning, in 247 years of American jurisprudence, we have never seen coordinated attorney rebellion during active federal proceedings. The Constitution assumes good faith participation from all parties. When that assumption breaks down, the entire adversarial system collapses. This isn't partisan politics, this is constitutional mathematics, and the equation doesn't balance anymore. Behind every constitutional crisis are real people whose lives get caught in the machinery when it breaks down. These aren't abstract legal concepts. These are human beings doing their jobs when the system they've devoted their careers to suddenly stops working. Let me show you what that looks like. Sarah Martinez, the 23-year-old court stenographer I mentioned earlier, has been working 16-hour shifts since Friday. Her job is to create the official record of everything said in federal court proceedings. But how do you create an official record when the proceedings themselves have become unconstitutional? Sarah told me yesterday, her voice shaking, "I've been taking notes on conversations that shouldn't be happening. Judges asking marshals to detain lawyers, lawyers asking the court to protect them from their own clients. Defense attorneys filing motions to have themselves removed from cases while they're still representing the defendants. I don't know what to call these things in my official transcripts because there aren't words for them. Let that sink in. The person responsible for creating the legal record of these proceedings doesn't know how to document what she's witnessing because it's never happened before in American legal history." Sarah works for the federal court system. Her grandmother worked for the federal court system. Her father worked for the federal court system. 3 generations of her family have helped make democracy function, and now she's watching it break in real time. Sarah continued, "Friday night, I called my grandmother and tried to explain what happened in court. She worked as a clerk for 37 years, and she told me she's never heard of anything like this. Lawyers don't refuse to represent clients during active proceedings. Judges don't order marshals to prevent attorneys from leaving. She said it sounds like something from a different country. And Sarah is not alone. James Chen, federal marshal with 19 years of experience, has been assigned to courthouse security during the constitutional crisis. His job for nearly 2 decades has been protecting judges, managing courtroom security, and ensuring orderly proceedings. Now he's been ordered to prevent officers of the court from leaving the building. James told me, I became a federal marshal to protect the constitutional process. For 19 years, I've made sure courtrooms operate safely so justice can function. This week, I've been ordered to detain lawyers who are trying to uphold their constitutional oaths. I'm supposed to keep people in the courthouse who believe staying would force them to violate federal law. How is that protecting the constitutional process? Think about that. A federal marshal whose oath is to protect constitutional proceedings is being ordered to prevent constitutional officers from fulfilling their own oaths. James described what it's been like. Saturday morning, I had to tell 12 attorneys they couldn't leave the building. These aren't criminals. They're not flight risks. They're respected legal professionals who've devoted their careers to the law, and I'm treating them like they're under arrest. One attorney, Michelle Torres, has been practicing federal law for 15 years. She started crying when I told her she couldn't go home to her family. She said she'd never been detained for trying to follow her ethical obligations. That is not abstract, that is real. Let me tell you about Maria Rodriguez, 28 years old, former campaign worker who spent 3 years organizing events and managing logistics for Trump rallies across 6 states. She quit her campaign position in November when she said the legal strategy became impossible to support. She's been watching the courtroom proceedings this week from the public gallery. Maria told me, "I spent 3 years believing I was helping defend constitutional principles. I organized rallies about law and order, about respecting institutions, about constitutional rights. This week, I watched my former boss's attorneys begging a judge to let them quit because continuing representation would force them to break the law. The same people I worked with for 3 years are now so toxic that lawyers with security clearances won't represent them. Let that sink in." Maria represents thousands of former campaign workers, administration officials, and political operatives who are watching their former colleagues become unrepresentable. These aren't partisan opponents. These are people who worked directly with the individuals now facing constitutional crisis, and they're telling us that something fundamental has changed. Maria continued, "I keep thinking about all the rallies where we talked about respecting law enforcement, supporting the courts, following constitutional processes. Now the courts can't function. Law enforcement is detaining lawyers for trying to follow ethics rules, and constitutional processes are breaking down. I feel like I spent 3 years of my life promoting something that doesn't exist anymore. Think about what that means for someone who devoted their career to institutional support, only to watch those institutions strain beyond recognition." Dr. Rebecca Chen, psychiatrist specializing in institutional trauma, has been counseling federal court employees since the crisis began. She told me, "We're seeing symptoms of institutional PTSD in career civil servants who've never experienced system breakdown. These are people who built their identities around institutional stability, and they're watching their life's work become impossible to perform ethically." Dr. Chen continued, "Sarah Martinez, the stenographer, came to see me Monday because she's having nightmares about creating official records of unconstitutional proceedings. James Chen, the federal marshal, is questioning whether his job even makes sense anymore if he's detaining people for following their oaths. These are symptoms of institutional collapse affecting individual psychology. The families are suffering too." Michelle Torres, the attorney detained in the courthouse Saturday, has 2 children who spent the weekend asking their father why mommy couldn't come home from work. Her husband, David Torres, told me, "How do you explain to a 7-year-old that mommy is stuck at work because the government won't let lawyers quit when they think their jobs have become illegal? How is that America?" And here's what nobody is talking about: the security threats. Mark Harrison, the lead attorney who walked out Friday, has received 47 death threats since his departure became public. His law firm has hired private security. His family has been relocated. Attorney Rebecca Williams, who filed one of the 12 withdrawal motions, told me she's changed her phone number twice, and her children's schools have been notified about potential security risks. These are the hidden human costs. Legal professionals who took oaths to defend the Constitution are now receiving death threats for trying to follow those same oaths. The system that was designed to protect constitutional processes is now endangering the people who try to maintain constitutional integrity. James Chen, the federal marshal, summed it up. "I spent 19 years protecting judges so they could make constitutional decisions. I spent 19 years protecting lawyers so they could provide constitutional representation. This week, I've been ordered to prevent constitutional officers from fulfilling their constitutional duties. I don't know what I'm protecting anymore." That is what institutional breakdown looks like when it hits individual human beings who've devoted their lives to making democracy work.